The seed of current EU derivatives regulation was sown at a meeting in Pittsburgh in September 2009, where the G20 leaders resolved that all standardized OTC derivative contracts should be traded on exchanges or electronic trading platforms where appropriate and cleared through central counterparties by the end of 2012 at the latest. They continued, OTC derivative contracts should be reported to trade repositories. They did not, though, say that uncleared swaps should be subject to stricter margin requirements. They waited to do that until 2 years later at the G20 summit in Cannes in November 2011. Still keeping to their 2012 clearing target, the ministers proclaimed that reforming the over-the-counter derivatives markets is crucial to build a more resilient financial system. We call on the Basel Committee on Banking Supervision, the International Organization for Securities Commission, IOSCO, together with other relevant organisations, to develop for consultation standards on margining for non-centrally cleared OTC derivatives by June 2012. And it is the outcome of that last statement for Europe that we are discussing today. After months of anticipation, the final draft regulatory technical standards, the RTS, covering margin requirements for uncleared swaps under EMIR, were published by the European Supervisory Authorities, the ESAs, on 8th of March 2016. The RTS are not so catchily titled Regulatory Technical Standards on Risk Mitigation Techniques for OTC Derivative Contracts Not Cleared by a Central Counterparty under Article 1115 of Regulation EU No. 648/2012 and have now been submitted by the ESAs to the European Commission for adoption. Today we are discussing, in the final draft of the RTS, an overview of the RTS, what products are covered and its future route to implementation. Who will be affected and when, including the new intra-group rules, the new rules for initial margin and variation margin, collateral and segregation requirements, new risk mitigation requirements and techniques, and legal and documentation challenges. What is being done and what has to be done. Turning now to the overview of the RTS and its passage and future route to implementation. The RTS have as their objective increasing the safety of the EU OTC derivatives markets, and they cover the risk mitigation techniques for exchanging collateral for exposures in non-centrally cleared over-the-counter derivatives. In particular, with the aim of reducing counterparty credit risk and mitigating potential systemic risk, the RTS require the exchange by covered counterparties of both initial and variation margins for OTC derivatives not cleared by a central counterparty. The rules outline what is eligible collateral for collateral exchange, as well as providing criteria to ensure the collateral is sufficiently diversified and not subject to wrong-way risk. The rules also provide a methodology for determining what collateral haircuts should apply. The RTS include a framework for the treatment of intra-group derivatives by contracts by counterparties and competent authorities, and they provide operational procedures related to documentation, legal assessments of the enforceability of agreements, and the timing of collateral exchange. All OTC derivatives asset classes are covered by the regulation with the following exceptions. During the two consultations, risks related to physically settled foreign exchange contracts were hotly debated. There was particular concern also that regulatory arbitrage between different jurisdictions should not arise. The RTS permit entities not to collect initial margin on physically settled foreign exchange forwards and swaps or principal in cross-currency swaps. Counterparties are, though, required to collect and post variation margin for physically settled contracts. The commentary provided with the draft RTS notes that as the EU currently has no universal definition for physically settled FX forwards, and that the draft RTS has delayed the application of the variation margin requirements for physically settled FX forwards because of this. A universal definition is likely to come under MiFID II, so the RTS postpones the variation margin requirements until the earlier of the date of entry into force of this delegated act and 31st December 2018. The commentary to the RTS also highlights that there is uncertainty as to whether or not equity options or options on equity indices will be subject to margin requirements in other global jurisdictions. On this basis, the RTS includes a 3-year phase-in period for these options with the objective of preventing regulatory arbitrage. So how did we get to here? After the G20 Cannes meeting in 2011 and the entering into force of EMIR in 2012, the route to a regulatory technical standard for margining of uncleared swaps had a slow route. The Joint Committee of European Supervisory Authorities, the ESAs, who are the European Banking Authority, the EBA, the European Insurance and Occupational Pensions Authority, EIOPA, and the European Securities and Market Authority, ESMA, released their first consultation paper in April 2014. This gave the preliminary view of the ESAs on margining uncleared swaps under EMIR. Minimum standards for margin requirements for non-centrally cleared derivatives were also agreed and adopted by the BCBS and IOSCO in March 2015, and this provided a global benchmark. This was followed by the ESA's second consultation on margin RTS for non-cleared derivatives, which was released on 10th of June 2015. And now we have our current final draft RTS, our topic of discussion today, released on 8th March 2016. The RTS for uncleared swaps are in final draft form, and this means that having been prepared by the ESAs, they have now been submitted to the European Commission for endorsement. The European Commission now has 3 months to do this. Following this, the European Parliament and the Council may, within what is normally a few weeks, object to any RTS adopted by the Commission. Once through the objection period, and if neither the European Parliament nor the Council has objected to the RTS is then published in the official journal of the European Union and enter into force on the date stated in the journal. Many of the provisions in the RTS take effect on 1st September 2016, so it is a tight timeline to have the RTS published in the official journal by then, but that is the timeline being worked to. EMIR has a straightforward classification of counterparties. It divides all entities into 3 categories: A financial counterparty, B, a non-financial counterparty exceeding the clearing threshold, so-called NFC+, or C, a non-financial counterparty below the clearing threshold, so-called NFC-. The last category, the NFC-, are excluded from the RTS such that they are not required to post or collect either initial or variation margin. As for the remaining 2 categories, all FCs and NFC+s will be obliged to both post and collect variation margin, although the rules here will be phased in gradually. This requirement will apply to the biggest users of derivatives when transacting with one another from 1st September 2016. The biggest users are those with aggregate notional amounts of derivatives exceeding 3 trillion euros. For all other FCs and NFC+s, the obligation will kick in on 1st March 2017. By contrast, the initial margin requirements will apply only to transactions between entities, both FCs and NFC+s, that have an OTC derivative exposure above 8 billion euros in gross notional amount. When counting the threshold, the counterparties should look at the average notional amounts for the last business day of March, April and May of each year for all entities in the group. However, investment funds are treated as a special case, and the thresholds here are calculated at the entity level, provided that such funds are not guaranteed or supported by any other funds within the group or by the investment manager. The IM requirements will also be phased in gradually from 1st September 2016 for the biggest users, so FCs and NFC+s which exceed the 3 trillion euro threshold. The EBA estimates only 12 institutions in the EU meet this criterion. The rules will be phased in gradually depending on the trading volume of the counterparty, and they will apply to all entities eventually exceeding the euro 8 billion threshold by September 2020. The RTS sets out certain additional rules for cross-border transactions and intra-group trades. As to its extraterritorial application, the RTS imposes an obligation on EU entities to post and collect margins regardless of whether they are facing EU or non-EU entities. This also means that third country entities which would be classified as NFC minuses, are outside the scope of the regulation. At the same time, the RTS recognises that certain emerging markets may not support the enforceability of the netting and/or segregation arrangements, which is essential for the effectiveness of the margining requirement. For these jurisdictions, counterparties should rely on alternative arrangements, such as posting collateral to international custodians. Where that is not possible either, the EU counterparty should only collect margins from its counterparty and not be required to post margins itself. When the laws of a third country jurisdiction do not allow for that either, the EU entity is permitted not to exchange any margin at all, provided that the amount of all of these uncollateralized trades does not exceed 2.5% of the EU entity's total exposure to non-cleared transactions. Another special case is intra-group trades. Article 11.6 to Article 11.10 of EMIR allows these trades to be exempted from the margining requirement if certain conditions are met. To ensure that EMIR is applied in a uniform manner across the EU, the RTS includes the details of the relevant conditions and the procedure for applying for exemptions. When a company group has affiliates in third country jurisdictions, the application of the margining requirement is postponed to allow the ESAs to determine whether the relevant third country's regulatory regime is equivalent for the purposes of EMIR. The specific provisions regarding the initial margin and its determination are set out in Articles 14 and Section 4 of the draft RTS, where you will find details of the initial margin determination methods. In short, the initial margin requirement is based on the following parameters. The IM provisions shall apply in relation to the netting sets agreed between the covered counterparties. Each of the two covered counterparties must calculate the amount of initial margin to be collected using either the standardized approach laid down in Article 15 or the initial margin models referred to in Article 16, the initial margin models, or both. The covered counterparties have to agree on the method each counterparty uses in advance. The total amount of the initial margin has to be calculated at least every 10 business days, or if earlier, on the business day following certain initial margin relevant events. In particular, in the case of a new OTC derivative contract, which is executed or added to the netting set, or for an existing OTC derivative contract which expires or is removed from the netting set. The initial margins are to be collected in one of the following ways, either by collecting in cash or non-cash collateral in accordance with the other requirements of the draft RTS for those collateral assets, and including the haircut requirements. Initial margin has to be collected within the business day of calculation. Finally, the segregation requirements of the draft RTS apply, and we'll cover this a little bit later on. With respect to the initial margin requirement, there exists the possibility to use a threshold of at least 50 million euro, which will be applied on a group level, and a threshold of 10 million euro for intra-group initial margin requirements. The use of this IM threshold has to be agreed in the collateral documentation. A minimum transfer amount may be agreed between the counterparties with respect to both the initial margin and variation margin requirement. Any minimum transfer amount arrangements for IM and VM are taken as a whole. However, they cannot be greater than 500,000 euros or equivalent in another currency. Where the amount of collateral due to the collecting counterparty exceeds the relevant minimum transfer amount agreed by the counterparties, the collecting counterparty is obliged to collect the full amount of collateral due without deduction of the minimum transfer amount. Initial margin is intended to provide an additional buffer to protect against fluctuations in the value of derivative contracts between the time when the variation margin requirement was last calculated and the time at which a contract is closed out. However, posting of initial margin involves the collateral provider taking additional credit risk on the collateral taker. If a very large dealer were to fail and counterparties that had provided initial margin to that dealer were not able to get their assets back swiftly, then this could increase systemic risk. For this reason, the draft rules, in line with the BCBS IOSCO principles, impose strict requirements on the way in which initial margin must be held. Segregation requirements must be in place to ensure that collateral is available in the event of a counterparty defaulting. In general, operational and legal requirements must be in place to ensure that the collateral is bankruptcy remote, either through the segregation in the book records of a third-party custodian or by other legally binding arrangements. Counterparties are required to perform an independent legal review to verify that these segregation requirements are met. This must be conducted either by an internal independent unit or by an external independent third party, such as a law firm. Upon the request of its competent authority, the counterparty must provide documentation supporting this compliance in each relevant jurisdiction and establish policies ensuring the continuous assessment of compliance. Although the IOSCO principles contemplated a limited right of rehypothecation or reuse of initial margin, the EU agencies have not provided for this possibility in the RTS, except for a limited right for custodians or holders to reinvest initial margin posted in cash. Following much criticism of the earlier draft RTS, a significant change has been made in the final draft to relax segregation requirements to allow for the posting of initial margin in cash. However, safeguards have been introduced to address the fact that custodians often hold cash collateral as banker rather than as trustee, and that counterparties may therefore involve exposure to the creditworthiness of the custodian itself. For systemically important banks posting amongst themselves, the use of cash initial margin is limited. A maximum of 20% of the total collateral collected from a single counterparty can be maintained in cash per single custodian. In addition, the RTS requires that all counterparties post cash with an unaffiliated third-party holder or custodian or with a central bank, and must assess the custodian's credit quality without relying solely or mechanistically on external credit ratings. Article 23 of the RTS imposes other risk management obligations on the counterparty collecting collateral. In particular, the collecting counterparty is required to have procedures in place to ensure, firstly, a daily re-evaluation of the assets held as collateral to ensure that they continue to meet the eligibility requirements, including the diversification requirements and concentration limits laid down in the RTS. Secondly, legal arrangements that allow access to the received collateral where it is held by a third-party custodian. Thirdly, where initial margin is maintained with the collateral provider, that the securities are maintained in insolvency remote custody accounts. Fourthly, that accounts for margin are maintained at central banks or authorised credit institutions which are unaffiliated with both parties. Fifthly, that the used collateral can be made available to the liquidator or other insolvency officials of the defaulting counterparty. Sixthly, that in the event of default of the collecting counterparty, the initial margin is freely transferable back in a timely manner to the posting counterparty. Seventhly, that non-cash collateral is transferable without any regulatory or legal constraints or third-party claims other than routine liens of the custodian or clearing systems. And eighthly, that the collateral is returned in whole other than costs and expenses incurred for the process of appropriation of the collateral. Under Article 31, counterparties are also required to have operational risk management procedures in place and to test these at least annually, including, firstly, detailed documentation of policy and procedures to be reviewed and updated as necessary at least annually. Secondly, a robust process for addressing policy exceptions and reporting material exceptions to senior management. Thirdly, agreement of the operational process for the exchange of collateral, including the levels and types of collateral required and any segregation requirements, the relevant derivative contracts, and the procedures for notification, confirmation, adjustment and settlement of margin calls, and for calculating margin and valuing collateral. Fourthly, procedures to periodically verify the liquidity of the eligible collateral. Fifthly, procedures for timely reappropriation by the posting counterparty of the collateral in the event of default of the counterparty collecting the collateral. Finally, Article 32 of the RTS imposes obligations on counterparties to ensure that written trading relationship documentation is executed between them when entering into transactions. This documentation should comprise all material terms governing the trading relationship between the counterparties, including payment terms, payment and closeout netting, events of default and termination events, and governing law. Counterparties are required to conduct an independent legal review of the enforceability of the closeout netting arrangements in each relevant jurisdiction and set up policies ensuring the continuous assessment of compliance. Although netting opinions already required under the Capital Requirement Regulation should satisfy this requirement. So the new rules are going to bring about some huge legal and documentation challenges. Amendments to existing bilateral documentation to implement the contractual right and obligation to exchange IM and VM will be required. And these changes will include providing a methodology and data sources to value transactions and collateral and to calculate VM and IM, incorporating procedures by which disputes concerning valuation of transactions and of assets posted and paid as IM or VM may be resolved, incorporating thresholds below which IM and VM need not be transferred, setting out revised collateral eligibility and haircut requirements, and having different provisions for VM and IM and non-regulatory excess margin provisions, as well as providing initial and margin segregation requirements and having new calculation methodology and collection timing mechanisms. So what is being done? The ISDA Working Group on Margin Requirements has several work streams in progress to help the market prepare for implementation of uncleared derivatives margin requirements. These include a data utility for identification of parties, an operational build-out, and a new collateral documentation structure which is in progress and will provide template documentation to address new initial and variation margin requirements, as well as protocols to provide scalable solutions for the industry transition to the new margin regime. ISDA is in the process of developing a self-disclosure form which will be available on ISDA Amend for parties to use and to provide counterparty status under applicable margin regulations, for example, financial end user or NFC+, as well as certain specific fields and definitions as well, as to whether IM thresholds are crossed in a particular year, for example. ISDA is also developing revised collateral documentation, which is designed to operate side by side with existing CSAs under a single ISDA master. Each of these new CSAs will potentially need to, and will be designed to, be usable for each of the relevant regulatory regimes, and be usable to address different and potentially inconsistent margin regulations. For example, if each of the parties is subject to different margin regulations. The scale of preparation for the new rules is massive. And with that, we end our talk. Thank you very much for viewing.